Okay, so I'll quickly start again. It should be well under half an hour anyway, so don't worry about going over. So I'm just talking about the unpredictable nature of the common intention element of constructive trusts. It seems obvious that this is a key component because it's in the name, but it is an element that doesn't get a lot of attention in the appeal courts because it is so sensitive to fact. And of course, appeal courts hate interfering with decisions of fact. But I do think it's quite important to revisit it because a lot of the authorities now are dealing with detrimental reliance and some of the more nuanced legal concepts within the common intention constructive trust. So what is it? Well, common intention constructive trust is, in a nutshell, equity's way of giving effect to the common intentions of the parties. Quite often what we're talking about there is when legal ownership doesn't reflect the true position. Of course, the presumption that you start with is always that the title does reflect the beneficial ownership. And so what the constructive trust does, it's equity's way of overturning that presumption. And that can be by words or conduct, but it's falling short of an agreement. So if two parties have agreed something, then we're talking about an express constructive trust. This is words or conduct, something that can be a casual conversation or conduct over time, that shows the truth of actually what the two parties intended. So again, what is intention? This is a citation from Lord Diplock in Gissing and Gissing, and it's cited in almost every case that's dealing with common intention. It's quite a paragraph actually to digest. He said this: the relevant intention of each party is the intention which was reasonably understood by the other to be manifested by that person's words or conduct, notwithstanding that the person did not consciously formulate that intention in their own mind or even acted with some different intention which was not communicated to the other party. I mean, quite frankly, that is something that is quite hard to digest. I'm not sure I would ever want to cite that in any submissions I was making. I think we all know what intention means. It's two parties with common accord, really, coming to the same desire, as it were, as to what they want for the property. And quite understandably, we're litigating these things, they don't agree. And where we have he said, she said, one word against another, what do we do with that? So I've been having a look at the authorities, and I started kind of the most recent and I worked my way back, and I was finding that we're still citing Stack and Dowden and Jones and Kernet. So I've said this is actually, I don't know if it's right. I asked AI to find me an image of Jones and Kernet, and it provided this image. I'm going to assume that this is the property they were arguing about. It was quite a nice family home, but in any event, I would say Jones and Kernet is a better place to start because it goes back over Stack and Dowden and tries to make sense of it. Both were joint name cases. So Stack and Dowden, we're nearly 20 years post Stack and Dowden now, and still it's quite a judgment to digest. So that was a case where both parties on the title and the beneficial interest was held unevenly in shares of 65 to 35 on the basis of a common intention constructive trust. Now, Lady Hale, as she then was, gave the leading judgment, but actually, if you look back over Neuberger's dissenting judgment, I think that's certainly one worth revisiting, especially how cases have progressed since then, because a couple of things he disagreed with in Lady Hale's judgment were her reliance on the couple having had very separate finances. That was something she put quite considerable weight on. And Lord Neuberger said, well, that's just not particularly relevant. And I think certainly these days it's much more common than it was 20 years ago. He also disagreed with the weight that Lady Hale gave to the factual circumstances after the property acquisition. So when we're looking at all the circumstances, he was saying really we need to focus on the circumstances as they were at the time of the acquisition, unless you are trying to establish a change of intention. So when we're talking about change of intention, we're talking about a new constructive trust being formulated. And that is what happened in Jones and Kernet. So that was a case where, again, both on the title, 50-50. Both parties agreed that at the time they separated, had they sold the house then, it would have been a 50-50 split. But actually, unfortunately, nobody did a separation agreement or anything like that, and they went off on their own paths. Mr. Jones enjoyed his own new property with the help of the separation finances, and Miss Kernock was left paying all the bills for the next 14 years on what had been the family home. So the judgments in Jones and Kernock, they get into a real debate about inferring an intention against imputing an intention. I wouldn't trouble yourself too much with it. Ultimately, again, when we go back to that first slide of what is a common intention constructive trust, it's equity's way of intervening. And ultimately, what the court did is they said a fair split was 90-10 in favour of Miss Kernock, and never mind how they got there. But I just revisit those cases because despite the age of them, they are still being cited regularly. And one of the last cases I'm going to refer to, which is Fatal and Fatal, in fact, the judge in that case does a summary of Jones and Kernock and Stack and Dowden in 7 succinct paragraphs. So if you don't want to read either of those lengthy judgments, you can just go to Fatal and Fatal, and I put the citation in the end. So, next point, more important for litigators amongst us, what evidence are we looking for? So you've got a client come in and he said that he wants to establish beneficial interest in a property different from the title. What do you want to see? So, of course, the documents. TR1, if a box is ticked, great. One thing on that, just be wary of some parties I've seen recently. There's been quite a debate as to whether if it's the vendor that signed the TR1 and not your client or the other party, just be wary about that. And if you've got any questions on that, please do ask, because there's been a couple of contradictory authorities on that. But TR1, mortgage forms, you've also got the property information form, any kind of instructions to a mortgage broker, that kind of thing, emails to and from conveyancing solicitor. Hopefully, conveyancers should have a file with all of this in. If there's something not in there, if you do obtain disclosure, then obviously ask for it. In a joint name case, of course, both parties should be privy to it. If it is a sole name case, and for example, your client isn't on the title, then of course you'll have to either get permission from the title owner, or you'd have to make disclosure application third party if they're not playing ball. But I would say the most important evidence in these cases, if you look at some of the judgments on
letters from financial advisors,
it's the text messages, it's the emails, and obviously the WhatsApps as well. It's become something. If you think back to some of these cases, we're talking about property that was purchased, say 10 years ago as an average. They're not thinking about disputes at that point. They're just being honest and open about their intentions to each other. And that contemporaneous expression of intent is what gets the most weight, I think, in courts. I've heard people being cross-examined and they've been asked, well, if you're right about that, how do you explain this email that you wrote? What did you mean? And sometimes they either just can't answer, they say they don't remember or they don't know, or they come up with a completely strange interpretation of what they said to suit their case. And these are the kind of investigations you can do with a client before things get off the ground or before disclosure, because these messages, they've got to be interpreted objectively by you advising your client. Be wary of a situation where the client suggests a different meaning to something from how you would read it. An example of that is the current client I've got right at the beginning of litigation, and he had put up almost the entire deposit on a property. I think it's about 90-10. His girlfriend put up a little amount. He wanted to pursue a common intention constructive trust on the basis of 90-10. The reason being they broke up very soon after they purchased the property. They hadn't even been in occupation for 6 months. They were both named on the mortgage. He had made all the mortgage payments, as I understand was the intention. But ultimately, he said, well, 90-10. And I could see the argument, but without any documentation other than his say-so, it was difficult to advise. He then wanted to add in a very small loan repayment that he said he had paid her as a loan, again, just before they broke up. I asked for any messages he had, and he sent me a whole load of WhatsApps between them. And in there was a message between them about the loan where he had said, don't be silly, I don't ever want it back. I just want you to be debt free. I want our home to be a home for our children. They didn't have any children. This was their children to be if they were. It was very much, it sounded like his intention was that he wanted to do whatever it took for them to be 50-50 beneficiaries. And despite what he said he meant by the messages, I really had to be quite strong in my advice to him that these are going to be read objectively. And memory can be tainted by emotions. And so that's just something to bear in mind when looking at the difference between the formal documentation and the informal text messages and emails. And what I would say is to not put too much weight on what a party has declared in a form. And the reason I say that is because I think courts are becoming much more readily willing to accept, not illegality as such, but that people do make declarations on forms to suit a particular purpose that is not necessarily reflecting their common intention. One example of that is where parents are gifting money to the couple or to one or other. It's declared on the mortgage form as a gift because that is more likely to obtain a mortgage to the couple, but everyone in the background has agreed it's a loan. Now, of course, hopefully they will have declared that somewhere between them, but often not. It might be buried in a text message or a spreadsheet or an email, for example. So a couple of examples. I'm just going to go skip forward to one forward slide, actually, before I go back to that one. So a couple of examples I've got here about that, where I suspect if I was advising at an early stage, I'd be thinking, quite strongly that the documentary declaration is going to be strong evidence. But two cases just to give some warning about that. So Parker against Parker Bauer, that's father and son. It always makes me sad when parents and children fight over their property. In essence, here we had as a father's property, and he had written up a statutory declaration gifting his interest in a property he was living in to his son, in order to avoid inheritance tax, amongst other things. He had also prepared a sham lease, I think, to generate some income when actually the money was coming from him. But the son later, after a falling out, relied on it, in essence, the statutory declaration, to say, well, you've relinquished all of your interest in this property. He asked for an order for sale. The father was still living there. What the father said was, well, in fact, there's a common intention, constructive trust between us, that I will maintain a life interest in this property, and the gift to my son was conditional upon him complying with certain financial commitments. That sounds something that would be quite difficult to prove to me, but in essence, the judgment goes into quite a lot of detail about the messages amongst the family, the wider family as well, emails, and so on at the time that really did back up exactly what the father was saying. There were family members who didn't seem to have a bias to one side or the other, as far as the court could tell, that did support this being a wider discussion amongst the family, the two elements. And the son's legal team said, well, you can't rely on that because that's illegality. You've accepted that you made a fraudulent declaration and you're now seeking the court's approval to establish that you are telling the truth about a lie that you told.
Bizarre, isn't it?
The court is searching for the common intention, and it seemed, on a balance of probabilities, that the common intention was, as the father had said in court, and he was successful. Another interesting case to read, it is a rather long judgment. It's Havedi and Havedi, that's from this year, 2025. Really complicated set of facts, lots of different properties. There was bankruptcy, a Turkish bank account, allegations of fraud. And in fact, it's interesting procedurally because the defendant failed to file her witness statement on time. And although we don't have the procedural judgment, the court did make reference to a litany of procedural failures from her, and she was debarred from from taking part in the trial and pursuing her defence. But even then, she did actually succeed in that the claim failed on quite a few issues. So the case, and it's a discrete part of the judgment, but Mr. Havedi, and in fact, this couple weren't married. She took his name. They were in a romantic relationship, but they were never married, even though she appears to have changed her name to Havedi. So he ran a case that the properties that he was arguing about, what they call the Sheffield properties, had been acquired in the name of the defendant to avoid his liability to HMRC. And the agreement, in fact, or the common intention as he pursued it, by way of his conduct and her conduct, was that Mr. Havedi, in fact, retained all the beneficial interest. And interestingly, that argument was unsuccessful on the facts. The court said there just simply wasn't any contemporaneous evidence to suggest common intention, constructive trust. But what they did say was that it would not have been defeated by that illegality, and that had that been the intention of the parties, equity would have given effect to it, and a denial of that interest would have been disproportionate. It seems that the matter was resolved by the defendant, in fact, signing a declaration of trust after proceedings had been issued that relinquished her interest in the properties. But if she had not done that, he would have been unsuccessful on the facts of his common intention constructive trust. So just two, I haven't put them on here, but you may be familiar with them on the issue of illegality. So Patel and Mirza, 2016, and then similar finding in Clears and Schlermer from 2018. And both of those discuss this concept of illegality and whether it's disproportionate to deny a beneficiary their equitable interest just because of illegality. And one of the key points from those two cases that I've just mentioned that differ from the Havedi one is that the illegality of Patel and Mirza and Clears and Schlermer was not orchestrated by the beneficiary, so undue influence or unknowing recipient. But in Havedi, it was his own illegality that he had orchestrated for his own benefit. So I was surprised by that decision of the court in Havedi, but of course, it wasn't the binding decision, and so it wouldn't have been worth appealing. So that's kind of an overview of being wary of documents and thinking that they are a smoking gun, for example. Just going back to this slide about fact-finding, something I think family lawyers use quite a lot, have fact-finding hearings, not something that we see so much in the civil courts. It's all wrapped up in the same trial, but it was referred to in the Parker case, this judgment. So the judgment of Dexter Dyers KC in the Powell and University Hospital Sussex NHS case from 2023. It's a personal injury case, but it's very interesting. I think it's something that we could all take something from when we're considering advising on factual disputes, because of course you don't have a crystal ball, you don't necessarily know how credible the other side are going to be, what witnesses they might have, what messages they might pull out of the woodwork that your client has conveniently lost or forgotten about. So a useful reference in this judgment at paragraph 25, where he separates out what he calls 13 points to consider when fact-finding in the civil courts. I don't want anyone to be counting because, quite honestly, some of them overlapped quite significantly. So if I only get to 10, it's not that I've forgotten 3, it's that they do overlap and they form, in my view, the same point. So number 1 was that the burden rests exclusively on the person making the claim. So that's quite obvious in these scenarios. If you want to assert something different from the legal title, it is your burden to prove it. Findings of fact must be based on evidence, and that includes inferences that can be properly, fairly and safely drawn from the evidence, but not speculation. Certainly come up against speculation quite a lot from opponents, and so that's certainly something that you can then use in closing speeches if that has been done. Third, the court has to survey the wide canvas of the evidence, and the factual determination must be based on all available materials. And evidence should not be evaluated in separate compartments, but each should be considered in the context of all the other evidence. So that's the kind of first section of it, and that was 4 different points. But I must just make clear, this isn't Dexter Dyer's analysing what he considers to be all of these axioms of fact finding. He's taken these from about 10 different cases, and he's conveniently put them into some bullet points for practitioners to use going forward. And then what he goes on to say is, takes a reference from family court. He says the court must decide whether the fact to be proved happened or not. Fence sitting is not permitted. So if the court is left in doubt, you go back to the first point. It's the party who's carrying the burden of proof to prove. He goes on. I think this is a useful reference, and I'm going to read out the whole sub-paragraph. There are important and recognised limits on the reliability of human memory. Our memory is a notoriously imperfect and fallible recording device. The more confident a witness appears does not necessarily translate to a correspondingly more accurate recollection, and the process of civil litigation subjects the memory to powerful biases, particularly where a witness has a tie of loyalty to one or other party. So that's certainly quite useful if you have a rather confident witness on the other side. It's not necessarily translates into an accurate recollection. Point 9, the court takes account of any inherent probability or improbability of an event having occurred as part of natural reasoning, and contemporaneous documents are always of the utmost importance, but in their absence, greater weight will be placed on inherent probability or improbability of witness accounts. And that's again what was recognised in the Havedi case, where there was quite a complex common intention being pursued from many years prior. And the court just said if that was the case, there'd be some kind of contemporaneous document, which there wasn't. And then just a couple of other points. The judge can use findings affecting the credibility of a witness on one issue in respect of another, but the court must be vigilant to avoid the fallacy that adverse credibility on one issue is determinative of credibility of another issue and should not render the witness evidence worthless. These are simply relevant. So that's obviously, I mean, it's a bit of a stretch that if your client is found to have lied about one matter, you're seeking to persuade a judge that there's a reasonable explanation for that lie, but not for the other. But obviously, we know that it happened in the Parker case, and he was able to pursue successfully his case despite having admitted to having lied. And then just finally, again, it may not be particularly useful, but decisions should not be based solely on demeanour, but demeanour fairly assessed in context retains a place in the overall evaluation of credibility. So long as due allowance is made for the pressures that arise from the process of giving evidence. So that's probably one that if obviously your client is not doing well in the witness box, then it's just maybe a reminder for the judge not to bear too much weight upon that because of the pressures of giving evidence. So we're nearly there. You see it's almost past. I know we had a bit of a slow start, but I think this is the final slide. And I called this, I mentioned it at the beginning, I called it the case of the missing £1 million. It's 2022, it's not a landmark case of itself, but it is a bizarre set of facts. And as I say, that paragraph, I think it's 81 of his judgment, Deputy Master Hanson does give a really useful overview of Stack and Jones, which, you know, I think I've seen it cited 2 or 3 times now since Vital. And that's how I came about it in a more in a higher level appeal court judgment. So it's certainly one that can be plucked out. The facts are this: 2 brothers. W bought a flat in London in 1972 using his own funds and already agreed in 1990 to transfer it to his brother for £400,000. They were both living in this property for almost the entire time of their dispute. I think the brother E, in fact, began renting it out in 2014. But between these times, 1972 and 1990, they were both living there. And what I've said is that £400,000 in 1990 equates in today's money to just under £1 million, hence the catchy title. So W transferred the title to his brother for payment of the £1 million, or as it was then, 400,000. But 30 years later, he brought a case alleging E had never paid him. Now, if this came through my door, I would not find it attractive at all, because how on earth has he not noticed over this period of time that he hasn't received his £400,000? And if you read the judgment, he does readily accept that £400,000 to him was not a lot of money and could easily have gone missing or not been noticed of having been paid. Very little documentation in this case. E counterclaimed that, in fact, there had been a common intention constructive trust from the outset, and that the brothers had always intended to own the beneficial interest in this property 50-50, and that in 1990 he actually wanted to buy his brother out. So the 400,000 reflected only 50%. It didn't really help him because ultimately the court found that he never paid the money. And in that respect, he wasn't entitled to the transfer of the property, and the transaction was reversed, and W then obtained his very valuable London flat back. It was even worse, the sting in the tail was worse, because E had to account back to W for all of the rental achieved over the 15 years that he'd rented it out. Maybe he thought he'd paid the 400,000 and he hadn't either. It all seemed rather strange and quite harsh. But yes, I include that case because, again, it's a case where you can quite imagine 30 years down the line, neither of them had their bank statements. It sounded like they had far too much money between them to start with, and why they wasted it on legal fees, I don't know. But obviously W did very well out of it. So there we are. The citation is there as well for the overview of Jones and Kernot. And I just had one other question. I had a question come in just before I started, and it was about issuing cases where the common intention is in dispute, and what part to use. So definitely part 7. I'm finding that unless there is no dispute of fact, such as an order for sale, where there's not really much to argue about, I'm finding part 7 is definitely the right way to go. But if there are any other questions, or if you'd like a copy of any of these authorities, please do send me an email, and we will get back to you as soon as we can. So it is exactly 5:30, despite the slow start. I hope I haven't rattled through it too quickly. But yes, please do look out for our next webinar, which will be coming next month. And thank you very much for taking the time to listen. Good evening.